Welcome to today's program titled Russia's Invasion of Ukraine, Navigating the Business Challenges and Legal Implications, Session 4, the effect of U.S. sanctions against Russia on commercial real estate documents. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording along with the CLE attendance form will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our moderator for today's program, Leon Rodriguez. Leon, please go ahead.
Good afternoon, everyone. It is my pleasure to welcome you for the fourth in our series of webinars on the legal and business implications of Russia's invasion of the Ukraine. My name is Leon Rodriguez. I'm a partner in Seyfarth's Washington, D.C. office and also the chair of our firm's government relations and policy group. Today, we have the opportunity to speak to you about the real estate implications of sanctions being imposed on Russia. You don't have to read too deep into the paper to know that, in fact, a number of Russians and Russian interests have had significant property holdings in the U.S., including real estate, and the questions of when and how sanctions may apply to them are significant and important ones, not just for them, but for other businesses in the U.S. As well. Today I have the pleasure of welcoming back Gordon Peary, who is a partner in our Los Angeles downtown office, who specializes in crisis management, regulatory, and transactional matters, and is our resident expert on sanctions. I also have the pleasure of welcoming for the first time Cameron Weil, an attorney in our New York office, who is a real estate expert. So Gordon, I think I'd like to begin today as we began earlier in the week, and that is focusing on sort of the 101 of sanctions. What is a sanction? How are they created? How do they apply, and how do you figure out if they apply to you? So why don't you give us the high level on all that?
Sure, it's great to be here again. Thank you to everybody attending. We realize that time is tight and very valuable and important, so we're going to give you just exactly what Leon kicked us off with in the way of a general overview first. Then my colleague Cameron is going to go into the deeper contractual parts of sort of what to look out for if you're in the commercial real estate space. And just as a little bit of background, I started my sanctions and national securities work working for a K Street firm in Washington, D.C., and had the great pleasure of being on the Hill and working with a number of government affairs, general counsel, and compliance folks in large clients. It's a thrill to be able to be with you today, and that's such an important lead-off question that I'll just say that most of you know about the sanctions, but maybe you need to know about sort of how they come about, and insofar as commercial real estate is concerned, we shouldn't just be looking at sanctions, but we should be looking for non-U.S. companies or companies that are American that are owned and controlled by non-U.S. parties, and not just Russians. So sanctions come about by first congressional action or an executive order. Then the sanctions, you have to kind of visualize it like three-dimensional chess. In fact, there are certain lists, there are certain countries and certain activities and financial institutions that are subject to sanctions. You're asked not to identify them, know that they exist in your deal, and we'll talk about how we do that, but also not to do anything with respect to them, and in fact take affirmative action by freezing or bringing about the freezing of assets. So those are sanctions. If sanctions aren't complied with, then there are maximum penalties. They range from, depending on the sanction, anywhere from 1 million and 20 years in prison as a maximum per sanction violation penalty, or if narcotics and other sort of greater offenses are involved, it's actually 5 million per sanction violation and up to 30 years. It's important to know, and we're going to be throwing around some acronyms today. It's very important for you to know sort of who does what within the sanctions environment and a few acronyms. So most of the sanctions enforcement activity, once an executive order or a congressional act is signed into law to make a sanction, is done by under the auspices of the United States Treasury Department. And so there are various, for your purposes, when you close a real estate deal, there's an office set up within Treasury called the Office of Investment Security, and literally all they do is scour the map for real estate transactions that involve non-US parties that may have, in fact, tripped certain Treasury or CFIUS regulations. So that's OIS, Office of Investment Security. There's something, of course, called OFAC, and that's the Office for Foreign Assets Control. And in this three-dimensional chess, to get to the practical punchline on this, it's important for you to know that there is a special OFAC sanctions list where you can actually type in, and we encourage, and we can help people in this process, type in actually the full names of non-US persons, and it'll all in one fell swoop get to whether or not there's a sanction involved. But there's a very important office called CFIUS, actually it's a committee that the Treasury Department chairs, that actually after 2020, in two brand new regulations, one of which applies strictly to real estate, requires you to be mindful of whether or not you have a covered real estate transaction that gives a non-US party the right of access to exclude others to develop and so forth. So there may be a filing that it may not be mandatory, but you may want to consider. And finally, we follow the money in the States with something called FinCEN. It's an office that tracks and helps enforce sanctions violations. And Canada and other jurisdictions have similar organizations called FinTrack in Canada, actually. So not just with respect to Russian investors in deals, we know that oligarchs and others have been outright sanctioned, but entities like FinCEN follow the money so that if you have a large fund that is capitalized in part with Russia or non-US money, you have to be aware of the regulations and the law, because and also use the URL that we'll be happy to give you so that you can see if there's a sanction that applies. Otherwise, you may trip either a CFIUS, Treasury, or sanction, and that would be a bad thing.
And it sounds like, Gordon, you know, some of there have been relatively recent, when I say relatively recent, last couple of years, regulatory developments that sort of increase the impact that sanctions can have given our current situation. Can you talk about those a little bit?
Yeah, it's a surprise to many in the real estate space in particular. And the big surprise and the big development was 2 years ago, and our New York office held a seminar where the Deputy Assistant Secretary of the Treasury, who ran CFIUS, actually spoke. And to get to what Leon is maybe referring to, is that all non-US participants in commercial real estate deals, depending on the level of control, depending on the location, whether the location of the property is national security sensitive, now must follow, for the first time in the history of America, a brand new real estate specific regulation that was promulgated formally by the Department of Treasury on behalf, as chair, and on behalf of this Committee on Foreign Investment in the United States called CFIUS. And so for the very first time, we have to be evaluating every real estate transaction to see if a non-US market participant, and there are a few countries on the white list, Australia, Canada, and the United Kingdom. But anyway, we have to, as commercial real estate practitioners, we have to figure out if a non-US deal participant can exercise the kind of control over property that's geographically interesting to CFIUS, or a business that may be a technology, infrastructure, or data business on that property. And then you have to determine whether or not there's a mandatory filing obligation under, again, what's called the Part 802 Seyfarth Rules. Now, in the history of all commercial finance in America, insofar as real estate is concerned, that's a first. These are brand new regulations. They're only about 2 years old. And, that's a really big deal. So you've got Seyfarth to worry about, but Leon, to finish the answer, and I'm sorry, I feel like I'm being a little long-winded, but you have to go to the OFAC sanctions list to punch in if you've got a Belarusian or a Russian investor or a participant in your joint venture, even your lease. You have to determine whether or not a sanction might apply.
And what if you get it wrong? What are the possible consequences of getting it wrong? And as you and I have talked about before, there's a spectrum here between getting it wrong because you made a mistake and getting it wrong because you're playing games. So maybe you can take us along that spectrum a bit.
Sure. So short answer is people do get it wrong. And that Office of Investment Security within Treasury, in fact, will alert people that they actually, under the relatively new 2-year-old Seyfarth rules for all non-US participants in commercial real estate deals, not just Russians, you really would have had to have filed a declaration or a notice under Part 800. So a mandatory filing obligation exists for your deal and you didn't file. And then you'll get a notice from the Office of Investment Security on behalf of Treasury. So let's say you get a sanctions wrong. If you didn't check, and again, we at Seyfarth are recommending across the board that all compliance departments, all legal departments in clients that actually do international deals with international parties, especially involving US real estate, to integrate in your KYC, in your check, in your AML, and some of the OFAC language that Cameron's next going to speak about, that you integrate a search, again, from the website OFAC sanctions list search, to punch in the details of a Russian participant in your deal. So let's say you get it wrong. Two things happen. You'll be your transaction may be frozen. The assets may be frozen by a financial institution, and you may get a notice from Treasury or some other department within even Commerce, and you can have the opportunity to petition or contest that. You can have the possibility of bringing about something called a license that would enable you to complete the transaction, especially if this took place before the invasion of Ukraine. And then OFAC will, and their chief deputies will, from time to time, issue licenses that allow the completion of transactions or the use, for example, recently last week, of the use of internet. But that's what really we're here for, is to help you if in fact you receive a notice or you have a question, if there's maybe a 50-50 ball as to whether or not you need to file a notice. We can help you through that, and we can certainly help if in fact a mistake was made.
So Cameron, I would have guessed that this, that your portion of this would be short, and you would say, just live right and you'll be fine. But in fact, this is complex, and the kind of document involved, the kind of transaction involved, will determine exactly how OFAC affects a transaction. So why don't you walk us through how all that works?
Yeah, that's right. And in addition to all the penalties, both civil and criminal, and all the notices that Gordon just talked about, you also have, liability under the documents you sign, because you sign a host of documents when you partake in a commercial real estate transaction, and a breach of a rep or a covenant in one of those documents could have pretty serious effects. So, for example, you breach a lease agreement, it can lead to a termination of the lease, which can then have a host of other effects, which we'll talk about in a minute. You breach a rep in your property management agreement, your property manager can have the right to terminate, so you would lose your property management services. If you breach a transfer provision in a joint venture agreement, your joint venture partner could buy you out. And most importantly, all these three things could lead to a breach of a representation or a covenant in your loan agreement, in your loan documents, which could lead to the lender calling a default, foreclosure, a cash trap trigger, which is when the lender actually sweeps all the cash and then you as the property owner don't actually have the rights to cash anymore. So there can be pretty serious ramifications to violating some of these things. And I think before we get into the actual documents, I think it's also just particularly important today, mostly because, I mean, obviously there sanctions were recently placed on increasingly placed on Russian individuals, and after the invasion starting on February 21st, the Office OFAC, the Office of Foreign Asset Control, identified a larger number of individuals that are actually called what we call specially designated nationals who you can't do business with. And that list has now significantly grown as of late February, compared to what it was before. So, yeah, go ahead. Oh, I thought you were going to ask another question there, Leon. So why is this important today? So since the invasion and since the sanctions have started, FinCEN, the Financial Crimes Enforcement Network that Gordon just talked about, issued 2 reports talking about potential evasion of sanctions by sanctioned Russians. On March 7th, they issued a report alerting all financial institutions to be vigilant against efforts to invade U.S. sanctions, and then listed potential red flags, which are things like, things you would normally watch out for already, like using shell companies and using third parties and using corporations to shield assets. And then on March 16th, only a week later, FinCEN issued a second alert specifically with respect to real estate, noting that sanctioned Russians might actually evade sanctions through the purchase of commercial and high-end residential real estate. And this report specifically says that real estate in particular lends itself to storing and hiding wealth due to its high value, potential for appreciation, and use of layered transactions through corporations and other LLCs and other types of entities to actually hide the ultimate property owner. So all this makes it really important that you don't actually violate any of these provisions, both because there's, or any of these sanctions, both because of what Gordon talked about and the specific types of documents that you sign as a commercial real estate investor. So I think it'd be best at this point to run through those documents that you sign on a daily basis and what OFAC provisions usually look like in those documents. So the first most common type of document you sign as a real estate investor are non-disclosure agreements. They're short agreements. They bind the receiving party getting property level information to keep the information confidential. You usually don't have any OFAC representations in these documents, but as a buyer, you should just be on the lookout and confirm if there are any OFAC representations that you can actually make them. Search these lists that Gordon was talking about. Reach out to us. We could search them for you. But you should make sure that you're able to actually give that representation. And if you happen to be asked by a seller to make a rep, then you can ask the seller to make the same rep, and they should really be able to make it. And when I say rep, I mean representation. They should be able to make it without an issue. But typically in an NDA, a non-disclosure agreement, you don't have an OFAC representation. When you get to the more serious documents, like the purchase and sale agreement, which actually governs the acquisition of real estate, which is the majority of my practice, those always have OFAC representations. And they typically say that neither the buyer nor the seller are actually on any OFAC lists. Buyers usually don't want their OFAC representations to pick up their investors. And this is particularly important because when you sign the purchase agreement, you might be 2 or 3 months away from closing, and you may not know who your investors are yet. So you really can't make representations up front as to your investors because you don't know who they are. And on the other hand, buyers do want their seller OFAC representations to be as broad as possible. So then the buyer can later turn around and make the same rep that they are getting from their seller, make a rep to the lender that they haven't done any business with anyone on an OFAC list. They might need to make this representation to an investor or to their lender. The third type of document, commercial leases, signed very often, obviously, in real estate deals. Typically, a landlord usually has a form. A landlord will send out their lease form to the tenant, and most landlord forms will have a representation in it that says that the tenant is not on an OFAC list and they're not conducting business with anyone on an OFAC list. And it's particularly important for the landlord to actually get this representation because the landlord needs to turn around and represent to their lender that they haven't done any business with anyone on an OFAC list. And who are the owners doing business with? Their tenants. So they need this representation from their tenant. And on the flip side, if you're a tenant, you should carefully look at the OFAC rep that you're being asked to make sure you're able to give it, because you don't want to breach it and be in breach of your lease either. And I think something to note here, and we'll talk a little bit more about this in the context of raising money as a sponsor of capital raising on the property owner side, but a public company tenant, a tenant that's a public company, wants to actually, you might not want to make this representation as to your investors because you might not know who all your investors are. So, we're not saying don't make the representation, but just be mindful and look to see how deep the representation actually goes, and are they asking you to represent, indirectly or inadvertently to your investors, because you may not be able to make that representation without doing some diligence. The fourth type of agreement, property management agreements. These actually, this is what governs the management of your asset. And it can either be with a large property manager like a Cushman & Wakefield or a Newmark, or a small, more regional property manager. And typically the bigger guys, like a Cushman or a CBRE, they might have more negotiating power. They might be regulated by more parties. So they may ask for these OFAC reps. But usually in a property management agreement, there will be a mutual representation from both parties going for the benefit of each other, that neither the manager or the owner are on an OFAC list. And like in the lease context, this is important also for the owner, for the landlord, because they need to make that representation to their lender that they haven't done any business with anyone on an OFAC list. And other than a tenant, the landlord or the owner is also doing business with their property manager. And that leads to, I think, the most important type of document, which has the most important ramifications, your loan documents. And Gordon and I work a lot together on these, making sure that OFAC reps and CFIUS reps are actually, in line and market and not overreaching and overbearing. So your loan documents obviously govern your relationship between the lender and the borrower. If you're buying property, you typically will have a loan on. And since the lender puts most of the money up for the property acquisition, if there is one, they really want to know who their borrower is. And also, by the way, most banks are heavily regulated by a lot of these institutions that Gordon just talked about. So the loan documents do usually have the most stringent representations, and there'll usually be a representation that says that no one on any OFAC list has any direct or indirect interest in the borrower. And there'll also be a covenant, an ongoing covenant, that says that the borrower won't engage in any dealings with any parties on any OFAC list, which is why I was saying earlier that in both the commercial lease and the property management context, you need to make a representation, and this is the example of it, that you're not doing business with anyone on an OFAC list to your lender. So because these are broad representations, it's important to also ask yourself the origins of your equity and really protect yourself with what I like to call back-to-back representations in your joint venture and fundraising documents that you actually get from your investors. And also here, it's probably important to stop for a second and talk about the distinction between direct and indirect owners. So the rep usually picks up that the lender asks for. It usually picks up both direct and indirect owners. So if you think of a typical organizational structure, your borrower is owned by like a blocker entity or a special purpose entity. And that's the direct, or then by borrower, I mean, sorry, the property is owned by your, a blocker entity or a special purpose entity. But that entity has all these other investor owners, and those owners are indirect owners. And people don't always appreciate that nuance there, because if the rep picks up your indirect owners, you need to know that your investors aren't on any OFAC lists. And the way you do that is by making sure in your fundraising documents, if you are a sponsor or fundraiser, that you get the appropriate representations from your investors. So in joint venture documents, if transfers are permitted, there's typically an ongoing covenant and a representation that says that neither party can transfer an interest to anyone on an OFAC list. And it's also really important in broader fundraising documents, not really a joint venture context where there's two parties, that you know that your investors aren't on any lists because the investors are picked up through this concept of indirect owners. And my practice, and Gordon also works with me on this as well, I spend a lot of time in the world of Regulation D private placement offerings, and in particular for Delaware statutory trusts, where we raise funds for clients through the broker-dealer network from accredited investors. And there can be as many as up to 500 accredited investors in one of the properties that we represent. So they'll usually be, the way we manage this, there'll usually be a representation in what's called the managing broker-dealer agreement, which is the agreement between the sponsor and the actual dealer of securities, who then sells the interests to the investors. And in the managing dealer agreement, it'll say that the managing dealer has procedures in place to actually ensure that no securities are sold to individuals that are sanctioned by OFAC. And then there'll also be a representation, so you're doubly protected, in your purchase agreement that's actually signed by investors, that the investors aren't on any OFAC lists. But this is also important in larger capital raising contexts, like REIT sponsors. REIT sponsors should also make sure that whatever purchase agreements their investors sign actually pick up reps from the investors that they're not on any OFAC lists. So, Gordon, Leon, those are the main documents in my practice where, you know, from the start of the deal, from the non-disclosure agreement to the purchase agreement to the lease to your fundraising documents, where I see these reps pop up and I see areas where clients should really be careful about making these representations because they really do have serious ramifications.
So, Gordon, judging by the efforts already made by FinCEN, it seems that the federal government is focused on preventing violations, certainly articulating the rules of the road. What can we expect from them in terms of stepped up efforts to detect violations and to take enforcement actions when they think there has been a violation?
Well, that's a great question. We don't see everything that they're doing, of course. What we encourage those on the line to do is to either work with us or monitor yourself, and we help train clients on how to monitor exactly the kinds of things that are good news to the market and some enforcement activity that are sort of cautions for the market. So the good news is that we absolutely need to be vigilant about what comes out of OFAC and FinCEN in the way of, especially from OFAC, in the way of exceptions or carve-outs to sanctions in the form of licenses. And especially these days, every couple of weeks we'll see a new license come out that shows, it's really a roadmap of what you can do in a prohibited transaction or insofar as the sanction is concerned. So we're looking for those licenses. We're looking for whatever publications FinCEN provides. And we also have contacts within both offices. So we're in touch with them on an informal basis. But if in my concluding thought, in light of time, the one thing that I would want you to take away from what Cameron said, as well as what Lean and I have been talking about, is that the contractual provisions that Cameron did such a great job crystallizing for us, those protect you contractually, or if they're not done right, they expose you contractually. And so they may be helpful in a CFIUS or an OFAC or a FinCEN action. But really what you have to do on top of scrutinizing your contractual provisions for contractual liability or protection is, and maybe you make the representation in the OFAC section in your loan agreement, but we're recommending that you go a step further and in fact run these searches through the OFAC sanctions list. And you can get that list by just typing in, and here's the URL, sanctions search, all one word, .ofac.treasury.gov. So even when you make a rep, go a step further with respect to an investor, a JV partner, whether passive or not, to plug in, and you'll see the degree of risk that you have in dealing with an individual that you may be on the fence as to whether or not trips that representation or even the sanction.
Great. As we are at the bottom of the hour, I want to make sure to read the continuing legal education code. That is S as in Seyfarth, S as in Shaw, 7398. Once again, SS 7398. Cameron, I want to give you one final word, and I want to perhaps touch that off with a question, which is, you read the papers, and this seems to be a South Florida phenomenon. I grew up near Sunny Isles, Florida. I assume this is really a national and even international phenomenon, and any transaction needs to pay attention to these issues.
Yeah, this isn't just really related to South Florida. Obviously, there's heavy Russian and potential sanctioned individual money in South Florida, but this is really all over, because you never know where people on these lists could be parking their money, and it's not just that area.
Great. Well, thank you both. As always, I learned a tremendous amount from both of you, so I appreciate your time. And thanks also to our attendees for joining us today. And with that, I wish all of you a good afternoon.
Thank you, everybody.